We are here in the chambers of the Honorable Henry Politz to continue his discussion of his life in the law. It is December 15th, 2001. I am Bruce Miller, one of his former clerks. Judge, you've covered your early childhood and your early years as a practitioner. I'd like to kind of move on now to your years on the bench, which of course encompasses three rather distinct segments. Your early years as an appellate judge, your years as chief judge, and your recent tenure as a senior judge, which I can attest that in the continuum between sweatshop and retirement tends much more towards the former than the latter. But let's see how you got on the bench first. Going back to your initial appointment, that was at a rather unique time in the Fifth Circuit. There were a lot of changes going on. At that time, it still encompassed the three southeastern states, Florida, Georgia, and Alabama. How did you first find out about being nominated to be an appellate judge?
Well, in 1978, I'm having to reach, was it late 77 or 78, after President Carter was elected. It wasn't too very long after that, Judge John Minor Wisdom took senior status. And we have the vacancy as a consequence of senior status. Now, those of us who were active, and as I was very active, as perhaps is reflected in some of my earlier comments, in the bar and in politics, in our area, in Louisiana particularly, but also the South, but Louisiana particularly. John Minor Wisdom slot, in all fairness and justice and smartness, should go to District Judge Alvin Rubin. We certainly all were in agreement on that. He was just as fine a judge as ever hit the bench. He taught at the law school and had been teaching at that point for 20 or 30 years. I don't know how long, but from the time he stepped down as a student, he started adjunct teaching, and he continued until his death. Extraordinary human being, highly respected by everybody. And I'll tell you a story off camera, just how much of a fine guy he was, about an experience I had with him. And so, I came to the office one day. I was busy trying some short matter, and I finished it, and I hustled back to the office, and I had to catch a plane to Washington because I had to see the next morning, deal with folks up at DOJ for a client on a matter of some consequence. So I grabbed my file, and I grabbed the mail, and I said to my secretary a few things, and she gave me a few messages, and I said, I'll call you from Atlanta, but I've got to get to the airport, and I threw the mail in my briefcase, and zip, I take off. And I get on the plane, and of course flying first class, you know, when you're on a client. And I have me a toddy. It's in the afternoon. It's like 2 o'clock, 2:30 in the afternoon. And we're getting airborne, and I'm opening the mail, and I open one. I look at the return address, I don't recognize it. I recognize the words, but not fully familiar with Western Fifth Circuit Merit Selection Commission. Open it up, and there's a letter from Bill Harvin, who's now with them, and has been with a major firm in Houston. I believe he's with V&E, or is he with V&E?
David Harvin's father, yes.
Yeah. He was chairman of the Western Fifth Circuit Merit Selection Committee. We later became obviously good friends. And I look at this, and my immediate thought was, damn, it took a lot of years, but it's here. What am I speaking of? I held the thing up to the light. And I said, hey, it's got a logos on it, gold. Boy, they went to a lot of expense. But fairness, you got to get even. You got to get even good. And what am I speaking of? This was a letter in which it said, your name has been suggested to us as a potential candidate for consideration for appointment to the seat on the United States Court of Appeals of the Fifth Circuit. And if you're interested, would you please do so and so and so and so and so and so, and then we'll give you a questionnaire and whatever. But, really? My first and immediate thought was, well, it's been 21 or 22 years. It's time for get evensy. I was reflecting on this in my senior year in law school, and I was not responsible. I claim innocence in all of this. I'm simply reporting what was done.
Whatever.
We had one of our classmates who was very, very bright. I shall not use any names. Very bright, top kind of student, bright as he could be. Made a one whale of a lawyer and has had a tremendously successful practice. The only thing bigger than his intellect was his ego. And he was on the Law Review, up at the top of the Law Review in terms of editors and so forth. He was 6 months ahead of me in school, so he wasn't in my class, but he was of the class. I finished in the middle of the year. I finished in January. He finished in May. And, well, there just needed to be something done, some people thought, to give him a measure of, a simple measure of, what would one call it? Humility, maybe, perhaps. So, traditionally at LSU, you have to quickly reflect on a tradition. Dean Hebert, I had mentioned this perhaps in my earlier discussions with Richard. Dean Hebert had been, as a very youngster, not long after he got out of law school, he had gone to teaching and became a dean. Became a dean down at Loyola. And then we had things happening at LSU, and they scooped him up and brought him to LSU Law School. And he was dean there at LSU Law School until World War II. He went into service, served, came back honorably. He was a prosecutor at Nuremberg, came back and was dean of the law school until I graduated. Until shortly before I graduated. He didn't sign my certificate, but it was only a matter of months.
So he kind of came and went, leaving vacancies periodically.
Yes, but he kept going back into practice to make some money. The dean got, in 1959, 1959? No, I graduated in 59. 1960 or 61, they offered me, because they knew I wanted to teach. They knew that. Dean McMahon called me, Henry George McMahon, and he said, "We've got a slot. Would you be considered to come back and teach torch and something else?" Oh boy, we just had our 5th child. Oh boy. Dean, what will I make? And he says, "I promise you," I said Henry George McMahon, Dean Hebert called me. "I promise you that you'll teach in the summertime," because the dean selects who teaches the 2 months in the summer. They get paid, actually, you get paid for 9 months. And then 2 months in the summer, even though you only teach 7 weeks. He said, "I'll promise you teach in the summer. I realize your financial situation." $11,000. $11,000? Come on, Dean, I'm gonna make in excess of 25,000. And $11,000 for a professor of law? And he said, "Well, Hank, full-time professors only make $12,500. I'm jumping you a step too." But there are 3 levels. Associate professor is one of them. Assistant professor, associate professor, and he jumped me to the second. He said, "I'm jumping you because of your experience, because of your military time, because of your record at law school, because of, I'm jumping you." And I said, "Jumping me? What does a full professor make?" He said, $12,500. I said, "Big Red and Wex are making $12,500. What are you making?" That's a hell of a note to ask the dean. He said, $17,000. I said, "Well, excuse me. I don't think I can handle that, Dean. I got a family and so forth." But he was kind enough to call me about that. The word was that Dean Hebert was going to go back into private practice. That was not new. That was a usual story. Frequently, it was very accurate, and it proved to be accurate again here. So one day, our friend got a letter, and it was from, according to what was there on the paper, from the president of the university, and saying, "Dear, as you probably know, it's become, if not common knowledge, certainly and those who are in sensitive positions know, that Dean Hebert will be going back into the private practice shortly. Reflecting back on our history, we had such tremendously good results of getting a new graduate in as dean, that it has been urged upon me and members of the Board of Supervisors that perhaps we should consider an outstanding graduate of our present, or who's just graduated or soon to graduate, and consider them. Would you consider coming, or would you mind coming by and interviewing with me or discussing this matter with me next Tuesday at 2 p.m.? Signed, General Middleton. Name just came to me.
Okay. This was on official letterhead.
Oh, of course, LSU, Office of the President. It's easy to get paper if you know the secretary. They told me.
Okay. So you've been told.
And signed, there was, boy, General Middleton's initials, / and some initials. Well, our friend showed this to everyone. Very impressive. I saw it and I was impressed. and so that next Tuesday, he goes over there and he said, I'm here for my appointment. Yes, sir, may I help you? Yes, I'm fill in the blank. And I'm here for my appointment with General Middleton. You have an appointment this afternoon with General Middleton? Yeah, boom, yeah. Good, yeah, yes, sir. General Middleton is in Central America. LSU had some great ties with Central and South America, bringing students up then and now. Okay. And he was on a visit to universities in Central and South America to get students. General Middleton is on a visit and won't be back until next week. Well, showed that paper. Well, she took it. She looked up at him and she said, I'll just say this. I do all of his mail. I type every one of his letters. You see my name, pointing at her nameplate.
Okay.
Those are not the initials. That's as far as she would go to say this is a fake. Some say she said, you've been made the brunt of. No, she didn't say that. I asked, oh, excuse me. I was told someone asked her what she said. And she said, pointed at her nameplate and those initials. So he knew he was had. And he pretended he knew all along. And I knew he was going to get even. So I'm on the plane and I said, damn, it took all these years, but he got even.
21 years later, he got you back.
He's gotten even, but boy, isn't this grand? I mean, this is quality. God Almighty, if you got to get even, this is really quality getting even. And so I went on to Washington, did my business, came back. And then I said, hell, maybe I should, at least I ought to call. No, I should, yeah. I said, well, no, yeah. So I dialed that number. I called Bill Harvin. And the secretary answered. I said, my name is Henry Politz. I'm an attorney in Shreveport, Louisiana. I have a letter from Mr. Harvin in his position as chairman of the Western Fifth Circuit Marriage Selection Commission. Does that ring a bell? She said, yes, he chairs that. Ah. And I have a letter from, yes, Mr. Politz, I recognize your name. So he answers the phone. And I said, Mr. Harvin, Henry Politz in Shreveport. I said, yes, Mr. Politz. I have your letter. Yes, how can I help you? And I'm thinking, well, damn, I got to make up some kind of lie. Well, it says I need to fill out a questionnaire, and I was just trying to expedite the process. And my secretary will send you a copy this afternoon. Thank you very much. Damn, it's real. And so, but this, hey, I can get some mileage out of this, man. Of course. People say, hey, consider him for the Fifth Circuit? What are you talking about? And my clients would know that, potential clients would know that? Absolutely. This is Ruben's job. I ain't got to worry about it. See, so until I got that damn thick questionnaire, boy, they want to know everything. You had to copy copies of the last 6 briefs you wrote. You had to copies of the opinions that you'd want, all kind of things. Man, it was a stack like that. Tremendously. It really was. And so I filled all. I said, well, I started on it. I told the man I'd do it. So I filled it out. I said, besides. And, you know, we carried this a little ways. Then I get a letter. He wants to interview me. So one thing, look, I've been getting some mileage telling people I've gotten this letter. Someone suggested I be considered Fifth Circuit, ho, 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 in a bottle of rum. But you know, sure, that's fine, but just how far are you going to carry this thing? Go to New Orleans for an interview? No, not do that. Looked at the date, mentioned something to my secretary. They want me to go down to New Orleans. She said, you're going to be in New Orleans that day and the next day. What have I got scheduled? She said, you've got an ethics hearing. I was chairman of the ethics committee. You got an ethics hearing scheduled on lawyer X. I said, oh, I do. I'm going to be there. And Harvin later laughed. I wrote back and said, I'd be pleased to come and interview with you if you could schedule me at the noon hour on Monday. I'm there taking. I'll be having an ethics hearing on a name, of course, I cannot now disclose. But I'll be taking a break for lunch, and I'll be glad to come over while doing that lunch hour, because it's only a few blocks apart, because they were at the Court of Appeals. They were in the Eastern Courtroom. They were in the conference room in the Eastern Courtroom. And I was, of course, at the State Board headquarters, which is, as you know, just 4 blocks down the street, if that. And so he looked at that and said, damn, okay. And he set me up for the noon hour. So I took a recess at whatever time it was, noon, 11:30, 12, and for an hour and a half, and let them go in. I scooted over there. And sure enough, within a matter of a few minutes, they take me in, and I do interview. And I'm as cocky as I can be. We still could smoke then. And hell, I'm sitting there in the interview chair, smoking a cigarette, flicking the ashes in the ashtray, and answering that question. And there's a doctor from Dallas-Fort Worth who was particularly obnoxious. And I had 2 or 3 lawyers I were on the commission. There were as many non-lawyers as lawyers, and they were from the 3-state area. But they had a doctor. He was an obnoxious dude, and my barometer ticked on him in a hurry. And I'm looking at him, and at some point he said to me, "I see here that you're on the, what is it? The Ethics Commission. You sit in judgment on your peers, or presume to," and then what got me was, "or presume to do so." And at that point, yeah, because boy, that was tough duty. And he said, the governor, called him by name, of Texas, asked me to serve on the, and he gave the name of the equivalent in the medical field, the Doctors Medical Commission on whatever, professional ethics or whatever. And I told him no, that I would not presume to sit in judgment on my peers. And I looked at him, I leaned forward, and I put my cigarette out, and I said, the Chief Justice of the Louisiana Supreme Court asked me if I would serve on the Ethics Committee, and as you put it, sit in judgment on my peers. And I said yes. The governor of Texas asked you to do the equivalent for doctors in Texas, and you said no. Who better to sit in judgment on their peers, except peers, to make a judgment call as to whether or not it was professional or not? I say to you, sir, shame on you. Would you believe that SOB did not vote for me when it came time to vote?
Hard to imagine, Judge.
I know, I know. That's exactly right. And so, at any rate, they went on down the road and they did that thing, and I went on about my business. And later, Bill Harvin and I had to laugh about this. He said, "Good gracious, but we didn't like that guy. He was something else, and we were so happy you put it on him." And they sent 4 names up. I understand from conversations with a former member of our court, who is now Attorney General. Griffin Bell had been on the 5th Circuit and had retired after 15 years or so. But after a year or so, Carter wins, and he becomes the DOJ, the Attorney General. He told me that this was the only time when they had a recommendation from the commission, or from a commission, where in this instance there were 4 names submitted, and 3 of them wrote and say, this assignment or this appointment should go to the 4th.
Al Rubin.
And that's something. Al Tates, myself, and Max Nathan, and Rubin were the 4 names they sent up there. Man, I'd get some mileage out of that. My name to Washington, boy, for the 5th Circuit. But Judge Rubin got it. Not everybody understood why it should go to Rubin. I didn't lose, you see. Yeah. Ha, ha, ha. They put me in the same category as Rubin, boy, if that ain't strong medicine. And so, of course, Rubin got it, and we were very, very proud of that. And damn, it was only a matter of a few months later. You might know the exact dates. Congress decided, after their study of all of the courts of appeals and the district courts, they had to add federal judges. And it was the largest increase. That's why President Carter has a reputation, has the what do we call it? The honor of being the person who has nominated the largest number of federal judges. Congress created a whole bunch of additional district judges and 35 court of appeal judges to meet the caseload that had been increasing in the several years, some 8 or 10 that since they had addressed numbers, and looked at the Fifth Circuit that had the busiest caseload of all at that time, even more than Ninth Circuit, and said there were 15 judges on the court, and said 15 judges can't be expected to handle this number of appeals. We need 26, and they added 11 to the Fifth Circuit. Well, darn, then I get this letter from Harvard. We have now been directed to make recommendations for 11 slots to the Fifth Circuit. And they're not filling slots so you know which state they're coming from. 11 slots, but the 6-state area.
Correct.
And would you, however he worded it, would you like to be considered? Man, that made it serious then. Then I had to look out the window and said, oh, damn. I could get this thing, maybe. Of course, that doctor may still be there, and ain't a chance, ain't a chance of that happening. And I really did have to meditate on that, although, and as I thought about it, because I enjoyed the practice of law, I really did, and was doing right well. And by that time, in 59, gee, all the children, not all of them, we must have had 7 by then. Shame on me. Boy, if I don't know better than that. 8? The family was almost complete. The twins were born in 71. And so, yeah, must have had 7 by then. And I looked at my pay, and my income was very good. I made about $160,000 that year. And I looked at the pay of a federal judge, it was around $50,000. It's kind of tight, you know. And had to meditate on that. Could I sell something on the side or something, have a job or something? But they said they were going to raise the pay too. They were going to be fixing to do a serious reconsideration of the compensation. Yeah, right. I hadn't got back yet to where I was when I came on.
In 1979.
In dollars. And we know a dollar isn't worth anywhere near what a dollar was worth in 79. Isn't that incredible?
That is
There's something wrong about that, and that shouldn't be on this tape. But there's something fiercely wrong about the pay for the federal judiciary, and they ought to take a deep breath and do something about it. I finally, but I did some serious thinking about it and said, you know, of all the courts that I've dealt with and seen what they were doing, there was no court that I had, including the Supreme Court of the United States, there was no court that I had a higher regard for than what the Fifth Circuit had been doing in the preceding 10 or 15 years.
Let me explore that a little bit, because in prior discussions you've talked about the civil rights work that the Fifth came up with, and several judges distinguished themselves in the 50s, 60s, and 70s. Now, you were a trial lawyer,
yeah,
and yet you're talking about joining the appellate bench as opposed to becoming a district judge where you could work at the trial level. What is it about the Fifth Circuit that enticed you to go to that level?
What they did. Well, pure and simple, what they did. The reality was we had trial judges who were ruling and were getting reversed. They were the product of their times. They were all of the other things that factor into it. The Supreme Court had made its ruling. The guidance was there. The reality that it was long past time to change. And lawyers and others who dealt with this fully cognizant of when are we going to just reach out? Sure, slowly we did the things that, since the country started, and to improve and to correct the obvious things that were wrong with what we were doing. The Constitution, for example, we're so very proud of the Constitution, and we should be proud of the Constitution. We look at the Constitution in the history of mankind and say, that's a marvelous instrument. Well, you look at that instrument and you say to yourself, you choke. Women are not real people. There's no provision for women to have any rights in the Constitution. Blacks are 2/3 of a person. Where did they get that madness from? It's in the Constitution, Buster. And how long did it take us? It took us a while before we finally give women the right to vote and to hold office and to be considered a human being. And it takes the Civil War and the 13th, 14th, 15th Amendments that were so important to us to finally give blacks their recognition in the Constitution that they're a whole human being and entitled to the rights of any other whole human being. God Almighty! Well, the reality was the instrument is not a perfect instrument, and we've amended it. Also, however, was that language that people thought was just, well, that's just dressing. The language in the Constitution, especially in the Bill of Rights, about things that government must do and must not do, that really had not been addressed and really given consideration to. Not the least of which was, well, what about these post-Civil War amendments, where we just had a battle over this question, especially about blacks and their position. We just had a battle where we killed each other, and Americans fighting and killing Americans, and to deal with this now. And then we passed these the constitutional amendments, and what do they mean? And the Supreme Court finally grabbed a hold of it and bit into it, and said, "Yeah, we got to consider this language," and did. We talked about it in law school, but it's just talk. Not just talk when the Supreme Court does it. And then the Fifth Circuit, when the Supreme Court kind of left it to the others, boy. And I suppose there's nothing inappropriate about that, because they deal with general principles, and specific applications should come from the courts that are actually doing the doing at the trial and the appellate level. Who grabbed a hold of it and ran with it? Maybe one would have to say it's because of our location. We're in the South. We had the 6 states of the South where the bulk of this was occurring. Not all of it, but the bulk of it. And therefore, the obvious place, and as it turned out, we had at least 4 judges and others, but certainly 4 judges who were ready to grab a hold of this thing and say, yes, we'll take the flack that goes with it. And don't think there wasn't some flack. We had people like Leander Perez who were out there parading around the Fifth Circuit building about what terrible things the Fifth Circuit was doing inside that building. My goodness, I remember that. And others, and the hate statements that were being made, and they just went right down that street, boy, right down that street, and they started doing that thing, and others fell in line, even the Supreme Court. And it was not the leadership, as I saw it, rightly or wrongly, and I happen to think I'm right, but rightly or wrongly, the leadership and the real meaningful changes in civil rights in this country was not by the High Court, but was by those judges on the Fifth Circuit who had the foresight and the intelligence and all of the things that really count, the guts to do it. And then to be considered for that court, I said to myself, well, you're going to make a lot of money if you stay where you are. Is that what you want? You're at the practice now 20 plus years. You're entitled to it. You work for it. And I said to myself, and talking to myself, it's bad when you're talking to yourself because people think you're crazy. But you got to talk to yourself and nobody else is listening. And said, no, I said to myself, no. That's not what I'm not interested in. And when I finish my time on this veil, the so-called veil of tears, and it's not that at all, it's a wonderful veil, that they can say, look, he left in the state of X, but maybe something else. And I said, I think I'll do that, and so I'll let it be known that I was interested in, and went down the road. Except this time it wasn't fun and games.
So this time, Judge Rubin is already on the bench.
He's on the bench.
So now there's a realistic expectation that you might attain the position.
My name had gone up there.
You had 11 positions
and
open.
They had 11 to fill, and I'd been one of 4 that had been sent up, and it figured that I'd probably have my name sent again. And it was a hard decision because, and not the least of which because of the dollars, the reality of the dollars. I looked at checkbooks and I saw what my wife was spending on an average month, and it was far more than I was going to make gross, much less net, as a judge. Just, you know, and those things had to weigh rather heavily. I had a little cushion. I figured, well, a few years, by the time they may raise the pay. And so I did apply. But this time when I went in for my interview, I sure was glad that doctor wasn't in there. It wasn't fun and games talking to those people. Because this time I kind of wanted it. And
the ego comes in.
Yeah, it wasn't as much fun just giving them hell. But they didn't rough me up. They were very, very nice to me. And of course, they sent the names in, and 7 of us. We went up there and had our hearings together. And this is when I meet the other 6. 7 people having their hearings to go in the Court of Appeals, the same Court of Appeals, the same morning. They never did it before since. And boy, you talk about preparation, you hear about all this preparation they do. They really did preparation during those times. I got a note from them, they're going to have the hearing at 9 o'clock. We'd like to have you at the DOJ room so-and-so, I think at 8. So we can prep us.
Okay.
You know, get ready for this thing. So we go over there, and they tell us what's going to happen. Thank you. And we go in, and 7 of us line up at that table. And our senators come in. Bennett Johnson came in for me. Russell Long was chairing the committee, and he couldn't come. He sent a letter. And Bennett said nice things. He and I had been same side of the case, other side. We were personal friends. And he said nice things. He was a very junior senator then. Then he read the letter from Long, who was a very senior senator then, and true for all of them. And they had the senators were there for some of them, representatives were there for some of them, but these were, El Jefe was one of them,
Okay, sure.
Judge Garza, Ronaldo Garza, and Judge King, and Tom Reevely, and Joe Hatchett, who later became Chief Judge of the 11th Circuit, is now retired from the court, and one of the first blacks on the 5th Circuit from Florida, and Lene Anderson, who's now Chief Judge of the 11th Circuit, and my partner from, shame on me, from Georgia. He died just recently. And well, there were 7 of us lined up there, and the chairman says to the 7 of us, does any of you wish to make a statement? And I'm thinking, man, I ain't gonna even make eye contact with you.
Yeah.
Make a statement? Lordy. And the voice next to me says, Mr. Chairman, I'd like to please, El Jefe,
Ronaldo.
Judge Ronaldo Garza. Mr. Chairman, pausing and licking like he's so want to do. When President Kennedy called me into his office to tell me he was going to nominate me for the district court, at that time El Jefe was not just on the Southern District of Texas, he was Chief Judge of the Southern District of Texas. Right. He had been at that 16 years on the bench. President Kennedy called me in his office to tell me he was going to nominate me for the Southern District of Texas. Said to me, Ronaldo, he called me Ronaldo, Ronaldo, I just want to say, do good, because they're going to be watching you. Mr. Chairman, I was the first Hispanic appointed to the court. Mr. Chairman, I must have not done too good. It's 16 years and they haven't appointed another one. Oh, man. I don't know if that's true or not. And Lord,
And you're cringing beside him.
Oh, God, I'm upset. And I knew I was going to like this dude, and of course I have such a great affection for him. And by that time, well, then I don't think, maybe Reevely might have said something. There wasn't a whole lot said by the rest of us, boy. Chairman laughed. He couldn't help it. He just laughed. And remember, other senators up there, they just couldn't help it. Here's a judge, been 16 years, a district judge, and he's sitting there saying, oh, God Almighty. So then he says, the chairman says, is there any, room was full, is anyone who would wish to be heard in opposition to any of the candidates? Boy, in the back of the room stood up. Said, would you come forward, please? And about 8 or 10 people start parading forward. And I'm looking to see if I recognize anybody. I don't recognize nobody. I said, oh boy, I wonder who they are. And they came in and lined up very politely. And the chairman asked them to identify themselves. From New York. New York. And they were members of what would be, I guess, activist civil rights groups. So the chairman said, and what is your opposition to Judge Hill? said he belongs to the so-and-so club in Atlanta. And there had been some press just about that time about how they discriminated against blacks. It's a fancy club and you have a clubhouse and a golf course.
Sure.
And I can't call the name of it. And I said, yes, all right. And what is your opposition to Mr. Anderson? He's on a school board of, and they called the name of the county that Lanier is from. And our organization has taken the position that we will oppose members of school boards and southern school boards who are responsible for the segregation of the races. Chairman nodded. And Judge, would you like to respond to that? And he said, yes, sir. He said, I don't belong, one would think of belonging as a member. I do have access to the club because they give access to the club to all clergy, military personnel who are at the rank of major and above in the area, and all judges. And so from time to time, I don't play golf, but I have gone there to eat supper, especially when we have a guest from out of town that I want to show off to. Okay. And then the chairman looked at his notes, and he said, and you oppose Mr. Lanier Anderson because he's a member of the school board. And the school board, you say, is responsible for segregation of the races. Are you aware, sir, that there was a resolution offered to that school board to integrate the races at the schools consistent with the court's opinion, and that resolution was adopted by the school board, and that resolution was offered by Mr. Lanier Anderson?
Settle that.
I said, no, sir, I was not. Anything further? No, sir. And they marched back. I said, all right, man, all right. And zip, whoop, zing, boy. All seven of us were favorable.
It was a big class. That was a big class.
Just went. And we got, we were nominated the first week in May, before my birthday on the 9th. We had our hearings, I think the 30th of June, the last week in June. And we were confirmed, and the president signed our commission on the 10th of July. Not 2 months from nomination to completion. What is that, 6 weeks?
They don't do that now.
God bless America. 7 of us, you know.
Right.
It could be done then, it could be done now, but the routine now is just atrocious of the delays and so forth. Look, how long has it been since a vacancy on our court? Since Brother Reevely, Brother Garwood took senior status. 4 years? John Dewey took senior status. Of course, his slot's now filled. April 2 years ago. Be 3 years in April. Of course, his slot's filled as of it's coming Tuesday. Judge Clement will take her oath. My slot's been open since August of 1999.
Correct. Still open.
Yeah.
So the 7 of you in this big class get nominated and confirmed in a very short time span. Hank Politz, trial lawyer, suddenly becomes Honorable Henry Politz, appellate judge. That's got to be a pretty steep learning curve. How did you adjust? How did you set up chambers and learn how to be an appellate judge? Tell me about the early years. It
actually turned out to be easier than I'd anticipated. Getting some simple basic advice from people like Judge Rubin and a couple of other judges that were on the appellate level, state Supreme Court. One that I'd been the campaign manager for when he ran for the Supreme Court, and saying, look, you're not trying this case. You're not the trial judge. You are on a court of errors. They've they've had the trial, they've had a decision by the trier or the jury, whether the judge or jury, by the trier, and now a complaint has been made that there's some error was done, and you ought to look to see if there was this constitutional error, a statutory, an error. I say, well, it was hard to grab a hold to the fact that we're a court of errors. We're looking to see if there was something so essentially wrong with it that there's a question in your mind, a reasonable question in your mind of the validity of the outcome. I thought about that really. I just kind of thought of the Court of Appeals as, well, this is my second chance to argue my case. Not really. No wonder you have such a high affirmance rate by appellate court, state and federal, across the board. And it's because of this very thing. And knowing full well that you weigh into the equation so many things that you can't really get out of a record the same way you get if you're sitting in that courtroom. And trial lawyers know that.
Sure.
I mean, a person can say words and what they really mean is exactly the opposite. And to a person who's hearing the words, the reverse is very apparent. The person who's reading the words, even though they got their three little dots to indicate a pause, just doesn't quite come across. And so when you get it through your mind, trust the trial judge, and that factors heavily into it. Trust the trial judge, then those credibility calls and things of that sort that you have to defer to and should defer to, then look to see about the legal and the constitutional questions. And they are not nearly as hard in most cases as it might seem to be. Although in some cases they're fiercely hard, but they're not really that hard. And also knowing the judge and knowing the judge's propensities and that factors into consciously and unconsciously.
You've worked with trial judges before. Now you're working in panels. You're working with colleagues. Tell us about what it was like for you to start having not to think just your opinion on the law, but working with others and coming to a consensus.
That also proved easier than I thought it would. The usual practice, and I've not been on a court where it has not been the practice, and I've sat now with a bunch of our other circuits, and I say a bunch, at least half of the other circuits since I've been in senior status. You talk to the junior person first. What's your judge? What do you think we should do with this? I think we should affirm because. I think we should reverse because. And then you discuss it. Well, yes, but I'm troubled because. Or I agree with that. And I would add. And we find, surprisingly, not surprisingly, but the reality that in far more cases than not, the judges are in agreement. After oral argument and had a chance to hear those questions back and forth and the answers, and the judges asking questions and so on, and you go back there and said, you know, I came in there thinking we had to reverse this, but now that I've got that, I think I came in there thinking we should affirm this, but boy, now that I've heard such, and it's just a rarity for a judge to say, I don't agree with that. You see how few you see how few dissents we have in a very real sense, and how, by comparison, how many cases are decided by a unanimous court. I think far more cases are decided by a unanimous court, whether it be affirmance or reversal. And that's a tribute to a number of things, not the least of which is a tribute to the members of the panel. It's just the opposite of saying, well, you're being sloppy. What one wants to do, everybody wants to do. It's a tribute to the panels that of doing their work of looking, and of course got these good staffs that they all work that can alert them to errors, and that's indeed what your staffs do. You remember your year as a clerk, the bulk of the cases that you saw, there might have been yeah, we could have done this differently. Yeah, we could have done this differently. But to see something done or that the trial judge failed to do, or the jury was an error, that was an exception. That was an exception. And if it was there, my staff member would likely catch it, or a staff member of one of the other two would likely catch it. And we'd have an opportunity to meditate on it, think about it before we ever got there. And then in the argument time, ask a question or two to settle any reservations you might have, so that when you get back in the conference room, the deliberations can be sometimes they're lengthy, can be very, very quick. I see that as an affirmance because it's not a perfect case, but I see this as a reversal because, and say it, and have the other judges, like as not, agree with it.
Did you have the opportunity to discuss the cases before argument to decide where the questioning should go, what questions you had to pose? Or
that's an absolute rarity. That's an absolute rarity to ever discuss a case before argument. I'm not saying it's wrong. I'm just saying that it's not a practice that we followed. Although it's not a rarity for somebody to comment before we go in. You know, in that third case, I'm anxious to hear what such and such. You know, that kind of comment. I want to hear what about such and such, or why didn't it do such and such. Yeah. Be anxious to hear
now,
that
in an en banc situation, of course, I mean,
en banc's a different horse.
A whole different horse, exactly.
Whole
right.
different horse.
What were the discussions among the different panel members there?
You know, in en banc, you know something of the position of the judge, because you've got a decision by a panel, whether it's a split panel or not. You've got a decision by a panel. You've got one or more judges who've challenged that decision for whatever reason, have assigned it in writing by the memos that we exchange, and you've got a vote of the court whether to vacate the decision by the panel, which is what an en banc vote does, and to take the matter before the full court for starting over again decision. And it's got to be a majority of the court that say yes to it. And you know who voted yes and you know who voted no. And some assigned reasons, some didn't. And so that en banc is a different ball game, just an absolute different ball game. Sometimes the en banc decision is easy because we need to go en banc because we got a panel decision that we don't want to follow. And we have a self-imposed rule that a panel must follow panels, and so that there'll be stability in the law. Lawyers can go and do research and they know what the law is going to be. They can tell their clients, this is what the court did, so we can expect the court to do this next time. And sometimes we look at things and we don't want it to be that way anymore, and so we got to take it en banc in order to reverse it. And that's not the norm. That's an exception.
Certainly.
But the typical thing is a majority of the members of the court either disagree with what the panel did or have real serious questions about what the panel did, either because they added too much into it or they didn't put enough into it, or the decision they came to they simply disagree with.
That's a beautiful segue into something, a thought that I'd like to take up with you at this point. In the most recent edition of the Almanac of the Federal Judiciary here, you are praised highly by the lawyers and comments about your time on the bench and your experience and your astute questioning. It ends, however, with one person that notes, "I am sometimes disappointed in his lack of addressing certain issues. If a case turns on one issue and he decides it, he won't address the other issues that were also raised." I would suspect that's very intentional. You like to write short opinions. You like to give guidance to practitioners in your opinions. Why do you like to keep things short and tight and not expound on the broader picture of?
Because I'm not writing a law review article, and I'm writing law, and if issue one decides the case, and I go in and discuss issues 2, 3, and 4, that's dicta, and that is not a holding of the case. It's a statement by one judge, which concurred in by either one or two other judges, by signing on, but signing on it as dicta. And I don't want to. My own personal view is, when you put it out there as the law, and the lawyers will look at it and say, this is the rule. They can tell their clients, and they can tell their students if they're teachers. They can say, this is what the court has said. Now the court indicated that they could do so and so when you got dicta. And there's some of my colleagues who just like to do that and write about those things. And I have always saw it as not helping in the law, but just the opposite. You want to talk like that, write a law review article. And just put your personal views, that this is, to me, the most sensible approach and why. Put it to law review article. not as dicta in a case. I want to avoid dicta like, I just want to avoid dicta in a case, if I possibly can, because I don't want the lawyers and the parties to be misled, because it doesn't bind the next panel. And you think it's right, and you jump on it, and you go down the road, and you make decisions with your client based on it, and the next panel that gets it said Politz was just wrong as hell, and zang and whop. You've got that, and they say, why'd you put me in that trap, they say to your lawyer, or whatever else they say to him. We did what you said, we just lost a bundle or whatever. And they said, well, the court said, well, no, dicta said. The judge decided he had to do a little law review writing in that opinion, and I try to avoid that.
I'm glad I was able to finally elicit a good zang out of you, because I was not going to be satisfied unless I get a good zang and whop coming. Do you feel Supreme Court is writing too verbosely now?
Always.
Always.
It's the nature of the beast. It's the nature of the beast. Otherwise, they'd be writing a page and a half opinions. You ever saw one of those from the Supreme Court?
No, can't say
No,
I have.
and you're not likely to. They've got to write that thing, and then they've got to have special concurrence at writing that thing, and they've got to have, you know. But that's okay. They're at that level. That's okay.
What role do you see in the appellate practice? As you said before about this is the issue of the law, the rest is dicta. Do you, as an appellate judge in your early years here, want to just lay down the letter of the law? Do you want to look more towards where the law should be? How do you balance letter of the law versus justice sometimes in your cases?
Yeah, yeah. Okay, this is a perfect follow up on what I just said in a very real sense. Sometimes you just feel compelled to give some guidance, although it's going to be dicta, because it's not needed for that decision, and technically, therefore, it's not the rule of the case, and therefore, it's dicta. Now, some folks have a broader definition of dicta, or more, just the opposite, a more confined view of dicta, so you can say more things and it's not dicta. Sometimes you want to give some guidance. You've got a situation, and the likelihood of this coming back up again is just not very real. But because of the cost involved, because of any number of factors that come to your mind, who's going to take this up to get it to the Fifth Circuit or to the appellate? It's just not going to be able to do it because there's not enough involved, but it's a thing of consequence in terms of how people are going to be doing their thing out there. And when you kind of get to that, you say to yourself, yeah, maybe you can write a paragraph of dicta and at least tell the lawyers and other judges how you feel about this situation. With that little bit of a variance change, that won't change the effect, or indeed will dramatically change the effect. And I can see myself ruling in this case on these facts, whack, whack, and then saying, and when you get to the lick log, it's dicta. Had we not had so-and-so in this case, it would have dramatically changed the legal situation, and the result may have been exactly the opposite because I could see myself being highly tempted to do something like that, even though, again, it's not part of the ruling, it's therefore dicta, because of guidance. But to just write in every, not in every case, but frequently writing cases, these all alternatives and saying things, I'm very reluctant to do that.
There was a judge, and I've forgotten his name, who used to always or occasionally say that, you know, when you come to an agreement in a conference, that sounds good, let's see how it'll write. Do you find yourself, when you get into writing an opinion, sometimes changing your viewpoint after you've agreed in conference?
Oh, absolutely. Oh, absolutely. Sam Johnson was fond of saying that. And a couple of others, Reuben being one of them, would say, that talks pretty good. Let's see how it writes, Hank. Or you'd say it to the other judge, let's see how that writes. And it's indeed so when you when you're putting it down and you look back again at what you just said, and you think you know what it's doing to this case, because you know the bottom line, you're going to say affirm, reverse, remanded, whatever. But what's it going to do? What's it going to do to this area of the law? And they see that's got to factor into your decisions. True enough, a lot of the decisions we have just decide in that case, period, paragraph. But more than a few of the decisions we have are building on the body of law. And we've got to be conscious of, yes, a fair result, a proper result, an appropriate result of this case. But now, when the rule that you're articulating, and being so quick to say, the rule that you're articulating, move that, think about it for a little bit, move it into the next fact situation and change a few facts that could easily, very easily, in that particular setting happen. And it doesn't take much to know what facts are easily changeable in situations after you've had a little experience. And say, look what this would lead to. Oh yeah, and this would then be what would be a fair resolution to that. And you got to think about that. It's not the kind of thing that you give, you don't talk about a lot, and not even with your staff. But it's got to be, when you're sitting there looking at that opinion, not necessarily the last time, before you let it go, you just got to see that language. Let me look at my holding and see if I am fixing to do more harm than good to what we consider the, quote, what's the technical term we use for the body of law? Lex loci, what? We don't want to do that. We don't want to do more. We don't want to do justice in the case and put into the law a basis for traps.
January 1st, 1992. Judge
okay.
Politz, appellate judge, turns into Judge Politz administrator.
January 15th.
January 15th, 1992. I do stand corrected,
Oh,
and you
yeah.
have corrected me often. How did that change your life here in Chambers, working when you...
Oh wow! Well, you became you become the chief judge, which gives you statutory responsibilities, and some others that are factored into the job itself. The statutory responsibilities in themselves are very specific and very can be very onerous. You are the chief administrative officer of all of the federal judges in the circuit. You are the one who, by statute, makes any number of decisions of what's going to happen to judges, qua judges, or individual judges in a given situation. You are the one to whom every complaint against a federal judge must be sent, reviewed, and acted on promptly. And you've got to take that complaint against the federal judge and other federal officials. Stay with the federal judges. Federal judge, and you've got to review it. You've got to get enough information in front of you to where you feel comfortable you can make a decision. Has there been a violation of the judicial code? Has there been a violation of those things that we consider the requirements of performance of a judge? And if so, if not, then you dismiss it with a letter of dismissal and say why you're dismissing it, and let the complainant know why, and let the judge know that you've done that. Because you send a copy of the complaint immediately to the judge. Every complaint. And sometimes you request an answer, sometimes you don't. You leave it up to them. If you decide that it's not there, done. And if you decide that, whoop, the statute says, and Congress put on the chief judge the responsibility, if you don't promptly dismiss it, you ought to appoint a committee to investigate it. And that committee shall be composed of an equal number of trial and appellate judges. And of course the chief. You serve on every one of them. You can't duck them. And so there'll be 2 and 2 and the chief. And that committee is charged statutorily then with doing whatever's necessary for an appropriate investigation. You may do it with paperwork sometimes. You may have to have witnesses sometimes. More likely the latter if it's a matter of any consequence. And so the committee then meets and they go over the complaint and they talk to the witnesses and they get input from the judge, and then they make a decision. If the committee says King's X, there's not a violation here, then it reports to the council, because the committee itself is just that. It's a committee. It has to go to the full council by statute of the whole circuit. And in our circuit, that's composed of 9 district judges, 9 appellate judges, selected by the appellate court, the district judges, one from each of the 9 districts, selected by the judges of the district, and the chief judge. Those 19 people make up the Judicial Council of the Fifth Circuit. Other circuits have their own judicial conference, and the numbers will vary from circuit to circuit. But ours, dealing with ours. And the committee must then report to the 19, and the 19 must vote. And what do we do with this? Up or down? The norm has been, what the committee recommends has been what's done. It is not the case all the time. The norm has been, it's a unanimous decision of the conference. It's not the case every time. And one of the duties. Other duties include, you're a member of the Judicial Conference as a consequence of being Chief Judge. The Judicial Conference of the United States is composed of the Chief Judge of each of the 13 circuits, plus a district judge from each of the circuits that have district judges, and the Chief Justice of the United States. That body has the authority from Congress to make decisions for the federal judiciary of all kinds, not in cases, but in everything else that involves courthouses, where, the size of staff, you name it. It's got all of that. The Judicial Conference realized it meets only twice a year, March and September of each year. Got things going on all year round. Got things going on every day. Got things in Congress. What's the position of the court on this? What should we tell the committee? What's all? So the chief has appointed what's known as an executive committee. And that executive committee of 7 judges have the power of the conference in between meetings of the conference. I served on that for my last 3 years as chief judge. And the phone rang every day. If it was a day it didn't ring, I'm having trouble remembering it, saying, what do we do about this out in Salt Lake City? Or what do we do about this in San Francisco? What do we do about so-and-so? What do we tell the Congress on such and such? What do we do? And making judgment calls. Part of the responsibility, if you are one of the chief judges who gets tagged. And it's been the norm for the Fifth Circuit to be tagged because we are such a large circuit, both in terms of the number of trial judges, the number of court of appeal judges, and the business, the number of appeals.
You succeeded Judge Clark.
Clark.
Did he help in the transition? Did he give you any guidance? Or was it just handing over the keys and you were on your own?
Handed over the keys.
Handed over the keys.
Because he resigned from the court.
Okay.
That same day.
So you got the entire Fifth Circuit in your hand. That time, again, it was just the 3 states, but that's still a pretty good load.
15 January.
And got to run with it. What changes did you make administratively to streamline? The caseload was getting just outrageous at this point.
Yes. Well, because I was chief judge, I got to add a law clerk. A 4th law clerk. Ostensibly, they help you with the administrative matters. So you spread that out amongst your crew, but it kind of effectively consumed effective time of one person. So we replaced that by having you have a 4th clerk, and you still have your 3 clerks to do you. Effectively, the time of 3 clerks to do you the work of chambers. And that worked out. I tried the first couple of years to have a continual clerk, and then I decided rotation was a better approach, and that's what I did for the remaining 5 years. And it worked out very fine for me, I thought.
What about streamlining the procedures of the court itself in terms of resolving cases, resolution, the screening process, that type of thing? What measures did you see needed to be taken to get things moving more quickly? Anything in particular?
Well, we changed clerks. We changed circuit executives. We hired but did not change the director of staff counsel. Anthony I was on the committee that hired Anthony just before I became chief, and he continued and is still the director of staff counsel. We put on the appellate counsel staff during the course of that 7 years, and which has worked to aid the court in the flow of its business, because they work toward causing the folks to seriously consider settling their cases, and there will be more than a few cases that get settled as a consequence of that assistance. The
AGN?
we found we've been constantly in search of ways that we can minimize the use of judicial time to reach a fair decision with an appropriate amount of judicial time. And one of the ways we found was to have our staff counsel. Well, when I went on the court, there were 15 judges, and then of course 26, and we had about 14 or 15 staff counsel. Now we have 60. When I went to court, Congress looked at the workload of the Fifth Circuit, the old 6-state Fifth Circuit, plus responsibilities for the Panama Canal. And they looked at the number of appeals that year, and they said 15 judges can't be expected to handle this level of appeals. Did the same thing to all the other circuits. That's why they added 35 to the total, but 11 to us. They looked at the filings that year, and they said, we cannot expect 15 judges to handle these filings. We need 26 to handle this number of filings. In 1978, we had 3,800 appeals. The year we just finished, we had 8,700 appeals for 17 active judges when we effectively only had 14. So that is kind of double plus, but we're not anywhere near doubling the number of judges. But in that number are an increasing number that we can handle very quickly by the judges by virtue of the nature of the case, the appeal that's being pursued, and by the assistance of staff that we have, staff counsel, for example, that we have who work on these matters. The many, many prisoner appeals, the many, many civil actions being brought by prisoners, the many cases that have resulted as a consequence of some changes in the law, Apprendi, and decisions by the court. So you appeal your sentence. So you pled guilty, of course, but you appeal your sentence. You complain about the judge, being mistreated by the folks here at the prison. The guards have been calling me names. We can strip that down to its essentials very quickly, and the judges don't have to spend hours on it, don't have to spend many minutes on it. If they look and see, well, this is what the issue is, and wow, zam. So we're able to move a number of things as a consequence of that. That's some are quick to make a charge, but you're turning over the judicial decision-making process over to staff. My answer to that is BS. You're turning over to the staff the responsibility to strip through a file and to get for you exactly what is the issue and what is the controlling law for this issue. And that's what they're doing. When they fail to do that, we tell them, get somebody else. But we rarely have to do that. And they can go through those files and pull that out for us, and so we can focus then on what is really the judicial question in the case with a minimal waste of time. And when you've got that, it's not the volume of the work that overwhelms. It's how much time does it take for each of the units that you're having to handle. And if you've got to spend 6 hours on something, boy, if you can spend 60 minutes on it, wow. If you can spend 6 on it, because you got a memorandum there, you read it and says, yeah, what? Well, come on, that's easy. This has got to be so-and-so. And you can dispose of it on that basis. And we've been able to develop, and that's all part of the things that we put in place and improved on in the last decade or so. And other than that, we would simply be lost. So we can then put the judicial mind to the number of cases that really need to be put on oral argument panels and to be heard and to be discussed by the judges in chambers. The perfect example of that is and I'm not throwing rocks at any circuit, I certainly don't mean to, but it's sitting with the Ninth Circuit. We have a docket of 32 cases, the last docket I sat on. The one I'm going to sit on in February, hope that I'm here for February, has 32 cases. I haven't examined this group, but of the 32 that we had on the one in San Francisco in September, at least 14 or 16 of those would be what we would consider screeners and never went to and didn't need to be on oral argument. Just didn't. We didn't need argument. We don't need to hear from lawyers. We've got the problem there. We have the record there. We have the law there. The decision there. And yet we got it on oral argument panel. Yay. We don't have the luxury of the time to spend, I'm not going to say waste, to spend injudiciously. That's a good word for waste.
It's a good word.
Good for waste. Injudiciously on this case, so we can save that time to put it on that other case that damn near requires it. And damn sure, I mean, not damn near, damn sure requires it. Damn sure requires it. So those kind of things. And it's just a question of finding ways to eliminate waste. Waste of what? Waste of the only things we've got. We've got the abilities and the time of the judges and the judges' staff. That's all we got. That's all we've got. You can play games with all you want. All you've got are the abilities and the time of the people who have the responsibility for deciding that case. And if we can maximize the use of that ability and that time, we're way ahead of the game. And we've tried hard to do that. And we've had some great success in it.
I would say that over the 7 years that you were chief, that obviously I think the flow of the cases has increased exponentially in terms of the time.
Went from 4,600 to 8,100 in my 7 years.
Amazing.
Or 8,200, just doubled.
Imagine that you barely got your head up in 7 years and found out that 7 years had come and gone and it was time to make a decision. So now you can either just go back as an appellate judge or you can take senior status. What was the thinking at that point?
Well, I wasn't anxious to take senior status. Knowing very much what I was doing. But I got to meditating on it. How wrong I was in my meditations. Some aspects of it. If I continue in my slot, that's it. If I take senior status, I can work at whatever level I choose to work, and I've chosen to work at a full level. I can work at whatever level I'm comfortable and choose to work, and that can put someone in my slot. And I said, you know, the workload is such, I stay here, even if I cut back 10%, I stay at 100%. But I think I'll go to other circuits, so I'll be cutting back maybe to 60% here. Somebody would be appointed to take my slot and it would cover it. Wrong. You know, here it is, 2 years and 3 or 4 months, and barely got a nomination, but he's in real trouble if I read the papers right.
So your strategy of getting basically 1.5 judges out of that at least didn't pan out.
Didn't work.
That's just Washington politics?
Washington politics. No question about it.
What benefits have you found in taking senior status?
I can go to the big benefit is I don't have to handle any more death cases.
Your clerks thank you.
I excuse myself, and my clerks, I'm sure, thank me. Like, no more death cases. God, I hate death cases. God, I hate death cases.
It's a difficult thing.
Oh, wish we'd never had them. We shouldn't have them. I'm against the death penalty. But I took an oath, and I have to remind myself I took an oath when I get these death cases, and said, no, you look at this thing and yay. But no death cases, and I'm free to go sit with other circuits, and I'm enjoying that.
Tell us about that. You mentioned the Ninth Circuit, your experience at least.
Sat with the Ninth, sat with the 10th, sat with the 11th. I'm committed to go sit with the Ninth in February. I was going to sit with the 11th, but I couldn't put it together. I'm going to sit with my circuit in January.
Okay.
And then in February I'm going to sit with the Ninth. And in March they want me to sit with the, what was it, also in February, sit with the 11th, and I just can't do that. I can't sit with 2 circuits in 1 month. Killed my clerks.
Again, your clerks thank you. I can vouch for that.
Tell you,
Been there, done that. How do you find the judges in the other circuits? You mentioned before the other circuits have different procedural aspects, and are the judges, do they think differently? Do they?
You know, not really. We read and we hear stories and we see people saying this judge is very conservative, this judge is very, very liberal, and I think they put me in the liberal category, don't they? I'm not sure where they put me anymore. I sat with one circuit, and I shan't name it, with the judge who has a reputation for being the most liberal member of that court. I sat a few months later with that circuit with the judge who has a reputation for being the most conservative member of that court. We handled 30 or so cases on each of the 2 dockets. I didn't disagree with either judge on one case. So that they ain't really liberal or really conservative. They're judges who are trying to see as best they can and do their thing. And that's been my experience. Some are keener than others. Some have a background which makes some things easier for them than others. But the judges that I've met in the other circuits are men and women, and I've sat with both, men and women who are trying to do a proper job of what they've got in front of them as they have the light to see. And it's very impressive.
Judges then basically put ideology aside when it comes to
put it aside.
applying the law.
Put it aside.
Have you found yourself being treated any differently by judges in our circuit or in other circuits since you've taken senior status?
None. Not the
No
least.
bowing homage when you walk in? No?
They don't bow and nothing, and they don't throw rocks.